Hey besties, welcome back to another episode of Lethally Blonde, where we're going to be breaking down some legal issues without making it really boring. You've got your girls, Carly.
Emily, of course.
And Avery.
So before we get into our new topic of the day, we're going to do a little recap of what we talked about during our last episode.
In case you've forgotten, last episode we talked about crazy last meals some people had before they were put to death, which was pretty fun if you ask me.
That's right. And as for today, we're going to talk about the right to effective assistance of counsel and the death penalty, then due process and the death penalty.
Also, as I'm sure you've noticed, we have a little bit of a different location this week because it's spring break. Um, Brief second. This is a dead squirrel I saw in front of my house. That's why it's my background.
And I'm in court, and then I don't know what Emily's doing down
I
there.
think I'm in a retro TV, but it's fine. It's
Yeah, so
fine. We're
we're
going back
having a
and
fun
looking at
episode.
stuff in the past. So,
Yeah, that is true. We have a little bit of a fun episode for you guys today. So let's stay tuned in and get ready because it's time to jump right in.
Bad boys, what you want, what you want, what you gonna do when Sheriff John Brown come for you?
so first, we're going to dive into the right to effective assistance of counsel and the death penalty. We will discuss how this right has exactly evolved and its impact on death penalty cases, then the legal battles following it.
But to do that, we need to look at the Sixth Amendment. The Sixth Amendment to the U.S. Constitution guarantees that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. But what does that really mean, and how does that even apply in the death penalty?
The Supreme Court has called the right to counsel the most pervasive of all rights, affecting a defendant's ability to assert any other constitutional protections. But for many years, this right was not applied uniformly, especially for those who could not afford a lawyer.
It wasn't until 1932, hence the TV, in Powell versus Alabama, that the court ruled indigent capital defendants had a right to effective legal representation. 30 years later, in Gideon versus Wainwright, expanded this right to all defendants under the Due Process Clause.
Which is strange because now, like, anyone can have a lawyer, regardless if you pay for it yourself or if the state appoints you one. Going off of that, having a lawyer isn't even enough. The lawyer has to be effective. In 1984, the Supreme Court clarified what that means in Strickland versus Washington. The court established a two-part test to determine ineffective assistance of the counsel. The first one is, was the attorney's performance objectively unreasonable? And the second one is, would the trial have had a different outcome if the lawyer had done a better job? Which is something I think is important to really analyze and look at because, now, if you have a lawyer that doesn't really do their job and do it as effective, it could hurt you in the end. Versus if you have a really effective lawyer and someone's guilty, they might get them out of it. But this set a high bar for proving ineffective counsel. Defendants must show not only that their lawyer made mistakes, but also that those mistakes likely changed the trial's outcome. What do you guys think about this?
You know,
Having a lawyer is really like expensive. So to me, it's like a waste of money to have a bad one because it could literally go either way.
well, and sometimes you don't realize that they're going to be bad, but I feel like there's so many lawyers out there that, have gone to like the bottom tier school or who just like want that lawyer status but don't really want to put in the work, if that makes sense. So that's also something to think about of like there are many crooked lawyers out there that like you don't know, you know?
Yeah, no, I agree. Especially let's just think if someone like killed someone and they have a really good law, let's say they have a good lawyer, but let's say like the other side of it can't afford a good lawyer. So they get some crappy lawyer.
Yeah.
Well, they're pretty much screwed. And
We
all of
can
it
think
too, like you
about
said, Avery, it has like credibility. Like what school did you go to? Did you graduate from Harvard or some school that everyone gets into for law? So
We
you
could
really
think
got to look
about
at those
O.J.
aspects of
Simpson.
it too.
You know what I mean? Like the O.J. Simpson thing. Like it's speculation that he did actually kill her, but it's like, did he? But he had that really good lawyer.
And also going into that too, like he's rich, which is something a little off topic, but it's something that we see too. Like in trial cases, like are they famous? Do they have a lot of money? Like that all goes into it. But and obviously he had a really good lawyer because he could afford like the best lawyer. So it's like kind of strange you have to really think about those aspects in our legal system.
Yeah, that is true. And in these cases of ineffective counsel, it's actually even more challenging for death penalty cases. So it says here the Anti-Terrorism and Effective Death Penalty Act, which is the AEDPA, limits the ability of death row inmates to challenge their convictions in federal court. So to succeed under this act, a defendant must show that the state's court decision was contrary to or involved an unreasonable application of clearly established federal law.
Additionally, adding to what Avery said, the Teague versus Lane in 1989 restricted habeas relief by ruling that defendants can't rely on legal principles established after their conviction, specifically after the fact. This means that even if new laws or Supreme Court decisions clarify ineffective counsel standards, they don't automatically help defendants whose trial happened before those decisions.
Honestly, like looking at that like point that you just made, like wow. So what you're saying, Emily, is that even if during it there was like an issue, it doesn't matter. Is that what you're saying?
That's what it looks like here of what has been established, because what my take on this is, if something happened that was not in their favor, okay, and you just got to deal with it. But if somebody makes, like, somebody of these two, of the new laws or the Supreme Court decisions happen after the fact, it doesn't matter. You're just out of luck, is the way I'm reading this.
Yeah, no, I agree with you with that. I was just asking to clarify a little bit, but no, I think so. Moving on, since Strickland, several cases have defined the boundaries of ineffective assistance claims. So let's go through these. First, we have Wiggins versus Smith in 2003. The court ruled that a lawyer's failure to investigate a defendant's abusive childhood constituted ineffective assistance. Next, we have Rampilla versus Beard in 2005. Defense attorneys failed to look into past criminal records that could have revealed mitigating evidence, leading the court to rule their performance inadequate. And finally, we have Martell versus Clare in 2012, where the court examined whether a death penalty defendant could replace a court-appointed attorney who failed to investigate key evidence.
Yeah, and on that note, I also have two more cases to add into that. So the first one that I'm touching on is Maples versus Thomas in 2012. And in that case, the court ruled in favor of a defendant whose attorney had abandoned him without notice, leading to a procedural default. And then the other one is Trevino versus Thaler in 2013, which expanded the ability of death row inmates to claim ineffective assistance when the state procedural rules made it nearly impossible to raise the issue earlier. So each of these cases have added layers to the legal standard, but the burden still remains high for the defendants.
I mean, I think these cases also too are like just great examples of this whole entire topic that we've been talking about. I mean, just like looking at them all, they do have things in common too.
Absolutely, for sure.
With all that being said, recognizing these challenges, the American Bar Association has provided guidelines for defense attorneys in capital cases. Since 2008, the American Bar Association has recommended extensive mitigation investigations, which means defense teams should thoroughly, and I mean thoroughly, explore a defendant's background, which would include childhood trauma, mental health, and social history, which is very important because how are you going to build a case properly and get a good stance if you don't know all the details?
Yeah, and honestly, like, yeah, even with these guidelines, recent Supreme Court cases have not always ruled in favor of defendants making ineffective assistance claims. Cases like Bobby versus Van Hook in 2009 and Wong versus Belmont's 2009 and Cullen versus Penholster 2011, where these cases upheld death sentences despite arguments that defense attorneys failed to present adequate mitigating evidence.
Another challenge in ineffective assistant claims is the role of an attorney's strategy. Some cases, like Bell versus Cohn, which was in 2002, and Florida versus Nixon in 2004, examined whether a lawyer's strategic decisions, such as waiving certain arguments, could constitute ineffective counsel. The court generally has been hesitant to second guess trial strategies as long as they appear reasonable.
United States versus Chronic in 1984 provided a rare exception, holding that ineffective counsel can be presumed if the lawyer failed to subject the prosecution to meaningful adversarial testing. However, this presumption only applies in extreme cases, such as when a lawyer is completely unprepared or inexperienced, which we need to hire lawyers that are prepared and experienced so this does not happen.
The right to effective assistance of counsel remains one of the most critical protections for criminal defendants, particularly in death penalty cases. Yet, the legal system sets a really high bar for proving attorney incompetence, and procedural hurdles like AEDPA and Teague versus Lane make it even harder for death row inmates to challenge their sentences.
As legal standards continue to evolve, one thing is clear. The quality of defense representation can mean the difference between life and death.
Which is really like scary to think about because one person can, affect another person's entire life because it's literally you can either be free or on death row until, the death sentence is carried out. So, with all of that in mind, we're going to move on to due process and the death penalty.
Well, Avery, what does it mean to have the correct due process when it comes to the death penalty?
Seems like we're gonna have to find out. So, to start, the Supreme Court has long held that due process provides more than just fairness. It offers heightened protection against government overreach, in fundamental rights and liberty interests. Nowhere is this more evident than in death penalty cases.
In Gregg versus Georgia in 1976, the court required states to create structured sentencing guidelines for capital punishment. So it ensures that decisions weren't arbitrary. Since then, due process protections have continued to evolve, ensuring fairness in sentencing, the consideration of mitigating evidence, and the defendant's ability to challenge the prosecution's case because laws are evolving all the time. People change, things change, society evolves constantly. So we need to keep these laws and things updated so, we can handle things properly as such.
Keeping due process in mind, let's skip over to mitigating evidence and due process. So, one major due process requirement is the consideration of mitigating evidence. In Woodson versus North Carolina in 1976, the Supreme Court struck down a law that mandated the death penalty for first-degree murder, stating that it ignored evolving standards of decency. This precedent was reaffirmed in Lockett versus Ohio in 1978 and Eadings versus Oklahoma in 1982, emphasizing that all mitigating factors such as age, mental health, and background must be considered in sentencing. Failure to allow this consideration, the court ruled, violates the 8th and 14th Amendments.
Due process isn't just about what evidence the defense can present. It's also about the right to challenge the state's cases. In Gardner versus Florida, which was in 1977, the court ruled that a defendant must have the opportunity to refute evidence used in sentencing. However, in Netherland versus Gray, which was in 1996, the court found no due process violation when a prosecutor introduced new evidence just a day before sentencing, because the defendant had the opportunity to cross-examine the witness.
Okay, so moving on to future dangerousness and due process. Capital juries often weigh whether a defendant poses a future danger to society, which is very important. In Skipper versus South Carolina in 1986, the Supreme Court ruled that a defendant's prison behavior was a valid mitigating factor. The court reinforced that any evidence that could influence sentencing must be considered, further strengthening due process protections because jail is not, jail, prison, all that, it's not a time to sit there and just go buck wild. You are in there for a reason. It's not a daycare center. You need to act properly. So, if you're sitting in there getting in fights, if you kill somebody in there, whatever, that needs to be considered because if you can't act right in prison, what makes, you think you're going to act right out in the, world?
Yeah, no, I agree with that. And another aspect we have of this due process is third-party guilt. So it brings up the question, can a defendant introduce evidence that someone else committed the crime? In Holmes versus South Carolina, 2006, the court struck down a state law that barred defendants from presenting alternative perpetrator evidence when the prosecution had strong forensic evidence. The ruling ensured that defendants retained their Sixth and 14th Amendment rights to fair trial. So let's look at that for a second. The court struck down a state law that barred defendants from presenting alternative perpetrator evidence. So even if they had strong evidence against somebody else, they still weren't allowed to present that. So even though they couldn't present that, which is wrong because if you had strong forensic evidence against somebody else, they're perpetrating you, like you're pretty much like out of luck. Which Avery's gonna mention here in a second, our next topic, which kind of goes into this, which is shackling and the due process.
Yeah, yeah. So imagine sitting in court shackled before the jury. Would that bias their perception? Make them think that you're more dangerous or scary. The Supreme Court has long held that shackling should be a last resort. Cases like Estelle versus Williams in 1976 and Holbrook versus Flynn in 1986 established that unnecessary shackling undermines due process by prejudicing jurors and interfering with the defendant's ability to participate in their defense.
With that being said, like, I know it's just common, like, even like sometimes if you go to the doctor or places that they take inmates there, and if you're there at the same time, if they're just handcuffed versus if they're completely shackled, like, you have a very different perception on them, which I feel like is just like a common, like, knowledge thing. Does anyone else have a thought on that?
Yeah, for sure. I definitely think that the appearance of like being shackled is definitely going like would definitely add to the bias of, oh, they're a criminal, they're this, it's not very helpful for their own defense because if they're sitting here and they look like a hard criminal or they look dangerous, then that's how people are going to treat them.
But don't you think like jurors they should be looking at like the evidence that's presented in like the case itself rather than like if that person is shackled? Because I mean, I personally have seen like a lot of videos where it's like people were like running out and trying to escape. So I mean, like, I don't think we should. I don't know if it should be. I really don't know if it should be treated like a bad stigmatism or not. I can understand safety, but I can understand overkill. I don't think we need to do overkill though. You know what I mean?
On
Yeah,
that,
it's like,
you're,
go ahead.
on that note, yes, you're correct. The jury shouldn't be biased, but they will be because they're
That's sad. You know what I mean? Like, that's sad.
Yeah, and that's what I was just about to say. Like we've talked about before in previous episodes, like there's jury bias. Like that's not something that we can eliminate. Unfortunately, it's gonna be there. So I feel like if someone's already biased and you add them being shackled, like that's really gonna like make them think, yeah, this is what it is because of this, this, and this, even if it's not true.
Right. That is totally correct. And I mean, like, they do go through processes of like trying to eliminate people from the jury from being biased, but like just that visual itself can create fear in a person. Because like, stereotypically you think of like a haunted house and you think of like, prisoners being shackled or like all these scary things, which like doesn't necessarily like, it's not gonna like flip the script entirely, but it could, subconsciously make a juror more biased because they are afraid, but they don't realize that, And, they're like, oh, they're a criminal, but why do you think that? Maybe it's because they're shackled, or maybe it's because of their appearance, but you don't really realize that, and you're not inherently trying to be biased, but it kind of just happens on its own.
Yeah, no, I agree with that 100%.
So, talking about jury biases, we're going to go into jury verdicts and the due process. So, what exactly happens if a court imposes a life sentence, may we ask? Can the defendant be retried for a harsher sentence? In Sadahasan versus Pennsylvania in 2003, the court ruled that a defendant who requests a retrial doesn't automatically retain their previous life sentence. The ruling reaffirmed the role of due process in sentencing while balancing double jeopardy concerns.
So, with that, let's go into psychiatric examinations and due process. So, psychological evaluations can be powerful tools in court, but they also raise due process concerns. In Estelle versus Smith, 1981, the Supreme Court ruled that using a psychiatric evaluation against the defendant without informing them of their rights violated the Fifth and Sixth Amendments. This case ensured that psychological assessments must comply with due process protections, which I think they should. I think if you are evaluating someone for something like that, I think they should be aware of what's going on. Like they should know about that. Like obviously it's their right to know.
Perhaps one of the most influential due process cases is Brady versus Maryland, which was in 1963, which requires prosecutors to disclose explanatory evidence. This rule has been expanded through cases like United States versus Aggers in 1976, Cohn versus Bell in 2009, and Smith versus Kane in 2012, reinforcing that withholding crucial evidence, even unintentionally, can undermine due process and require a retrial.
So, with all that being said, due process in death penalty cases is about more than just fairness. It's about ensuring justice, protecting fundamental rights, and preventing wrongful executions. From mitigating evidence to the Brady Rule, the Supreme Court has played a crucial role in shaping these protections.
So, let's wrap this up with a question for our listeners. Do you think due process is handled properly these days? And do people actually get effective assistance of the counsel?
That is a good question, Carly, and thank you all for tuning in to Lethally Blonde, and we'll see you next time with another juicy topic.
Stay smart, stay kind, and stay caffeinated. Bye.
Bye.
Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you?
All criminal prostitutions.
Yes, prostitutions, Carly.
Means that an
What is due process?
There's no way. Recording in progress.
no.
There's no way. Why do you have all these weird backgrounds?
I don't know. Wait.
That's normal.
Okay. Well. That's good. That's good. That's good. I like that.
Somebody else do one like this.
I'm in the courtroom, and Carly
That's
has
a dead squirrel.
I look stupid.
Really? You look stupid?
Carly literally has a dead squirrel behind her. No, go back. The other one was more fitting. Yes, that's perfect. Now,
Something done with their sentence. I'm pretty sure. I don't know. I could be completely wrong.
Bless you.
I was trying to hold that in for you guys to be done talking. guys.
What?
What?
Can you not see what's on the screen right now? Can you not
What?
see that? Can you see it?
Do what?
Can you guys not see that?
See what?
We have 9 minutes left.
I'm so
We'll just have to start a new one once it ends.
Yeah, hopefully.